6th and June 7th. And right now, I'd like to introduce Lisa Summer Devlin. She's practiced law since 1984, and she's had a focus on hospitality law for over 25 years. She drafts standardized contracts that many of you have probably signed, provides legal training for sales staff, and handles convention and meeting-related litigation nationwide for major hotel companies, including Hilton, Marriott, the former Starwood chain, and many independent hotels. She's been named one of the 25 most influential people in the media industry by Meeting News magazine in 2002 and again in 2006. And she has been deemed the legal voice for the industry. Quite a high honor. She served as a member of the Legal Advisor Council, as the contracts panel for Apex Initiative, sponsored by Convention Industry Council, and was president of the Academy of Hospitality Industry Attorneys from 2012 to 2014. Meetings and Conventions magazine have included her in its M&C's top 25 women in the meeting industry, and she's published numerous articles and hospitality-related topics and was the primary drafter of the American Hotel and Lodging Association meeting planner brochure. Before Lisa starts, we're going to do a little bit different format than we usually do. She has a presentation that we're going to bring up on the screen to help you follow. And I'm going to ask questions at the end. Now, 7 of you, as you registered, have already asked questions. But as she brings up the topics, you can send notes to Susan Hankin, our moderator, and Susan can get those questions to me, and I'll ask them at the end of the hour. All right? So without further delay, I'd like to introduce Lisa Summer Devlin, who's going to take over now and help us understand the myriad world of contract trends in our industry. Hi, Lisa.
Thanks, Jim. Thanks, Jim. Thanks, Susan. Hi, everybody. Thank you for having me today. When Stan asked me to do this presentation, he wanted to make sure that I was going to present from the standpoint of both the hotel side and the customer side, and I assured him that I would be happy to do that. While I exclusively represent the hotel side of the industry, what my job is to get good contracts for everybody. And when you're looking at what makes a good contract, that's really important, is to have one that's fair and reasonable to both sides. I've been around the industry long enough at this point that I've gone through multiple business cycles and recessions, and I've seen it be both a buyer's market and a seller's market, go back and forth numerous times. And I think that when you're thinking about event contracting, it's important that you recognize that when you're booking an event now that's scheduled to take place 1, 2, or 3 years from now, you can't predict what the business climate is going to be when it's time for that event to take place. So it's important that you're negotiating a contract that's fair and reasonable, and that you are not taking advantage of market conditions as they are at the time that you enter into the contract. Back when we were having the Great Recession in 2008 and 2009, it was definitely a buyer's market, and I saw a number of clauses, some of which we'll talk about today, that became popular that were really kind of overreaching on the part of the customer. And once the tide turns and it turns out that you've entered into contracts that are really one-sided, it makes your business not as desirable. And if you are known in the industry as being fair and reasonable and willing to work with the other side, whichever side you're on, your business is going to be more attractive than if you're the kind of customer that demands the moon and the stars and makes it harder for the other side to contract with you. So those are some of the things that we're going to talk about today. Again, remember, when you're entering into a contract, you're entering into a futures agreement. You are agreeing today to buy hotel inventory at a stated rate and on stated terms at a date in the future. And that's something you need to be thinking about, because it's just like entering a stock option. You're entering that deal, and both of you are taking risks, and you want to make sure that the risks to both sides are fair and appropriate. Let's go to our next slide, Susan. So that leads to the first industry trend I want to talk about today, and that's rate protection clauses. Sometimes people call them rate parity clauses or lowest rate clauses. These are those clauses that really came into vogue during the Great Recession, and they were really generated by the proliferation of internet rates. There have always been other rates available. When I started in this business, there were AAA rates and there were ARP rates, and you could always find a way to get a lower rate if you wanted. But the internet certainly has made it a lot easier for attendees to shop around and look for lower rates. And I know that in the incentive market that most of you are working in, the attendees room is being paid for by their employer or whoever the event sponsor is, and so the attendees aren't shopping rates, but it can still be important if you're the third party that's booking this event for the customer. It can be important to you to be able to show your value and say, look, I got you a good deal, and if your customer sees that you can actually go out and find lower rates than what they're obligated to pay, that sometimes that can create some issues. So when all of these things started happening in 2008, 2009, customers started asking hotels to guarantee that their rate would be the lowest rate available and that they wouldn't offer anything else. First thing you got to recognize is that that's not legally required. A hotel has no obligation to give you a lower rate just because they offer some other room a lower rate. I compare it to the airlines. If you pay $200 for your seat on the airplane and the guy next to you only paid $100, you don't get $100 back. That's just not the way it works. Hotels are volume sellers of inventory, and they have the right to whatever rates they want. And consider the flip side. Whenever a customer asks me, well, I want one of these rate protection clauses so that I know that I'm getting the lowest possible rate in the house, I always say, sure, I'll give that to you. If you agree that when it's time for your event to take place, if the prevailing rates are higher, you'll pay the higher rate. And I've never had a customer take me up on that. So again, you're saying I'm buying this inventory 2 years out, I'm agreeing on a rate, but if it turns out that that rate isn't the best deal, I want to get a better deal. That's not really the way contracts work. So understand that's what you're asking for when you're asking for these clauses. If, despite all of that, and one other thing to think about, the internet rate people are not getting 1 per 50 or 45 comps. They're not getting free meeting space. They're not getting suite upgrades. So it's not really an apples and apples situation when you're asking for these rate parity clauses. But if you are working with a customer and you feel that it's very important that you need to have this kind of a rate parity or protection clause, you need to negotiate it in a way that will make it easier for the hotel to accept it for you. And in that case, you should be the biggest player in the hotel. If you're going to a 500-room hotel and you're only booking 50 rooms, you shouldn't be really expecting a hotel to give you a rate parity clause because they need to sell those other 450 rooms. But if you're going to a 500-room hotel and you're booking 400 or 450 rooms, then a hotel is much more likely to be willing to agree to give you that kind of rate protection clause. Also think about the remedy that you want when you're negotiating that clause. Instead of saying, you won't offer a lower rate, but if you do, you'll give it to my customers or to my attendees. Instead of saying that, say, you won't offer a lower rate, and if you make a mistake and you do it, you agree you'll shut it off. That way you can go to your client and say, yes, there was a lower rate available, but it was a mistake, and now it's gone, and you're getting the best rate in the house, and you're not causing the hotel to suffer a big loss. Because when you have those clauses that say the hotel will match whatever the lower rate is, that can be a big financial hit for a hotel, and that's not something they're going to want to do. So that's the way you can handle those kinds of rate protection issues. Let's go to our next slide. Yes.
Yeah, if I could ask one quick thing there, Lisa.
Sure.
That's an excellent point you made about telling them to turn it off. So you understand our biggest dilemma on the incentive side is when people extend now, maybe 60% of people extend 1 or 2 days. And the client expects us to give them their group rate, and then if they call up and find out their group rate's $30 higher than they booked direct to the hotel, they complain and start trying to book outside the group rate for any extra attendees and stuff they had. So that's where your solution really, really would help us, is to get them to stop advertising that and just say it was a mistake if one or two slip in.
Sure, and that's one option. And then the other thing is, when you are booking those kinds of incentive trips, and if you know and you have history that half your people extend, then that's something that you should really let the hotel know as part of the booking process, and build in that they're, you know, I'm sure you already do say that the hotel will extend the rate based on availability, but the hotel may not want, based on availability, you know, on the flip side, they may not want to extend that rate because they may be able to get a higher rate. So you should really be letting them know to expect a certain amount of extension so that you'll have more availability there for you.
Great, thank you.
Sure. So going on with the industry trends, what's the response to this rate protection issue that everybody's so concerned about? A trend I'm really seeing in the industry, and again, I know this is less of a thing in the incentive industry, but it's something you should be aware of, and that is that organizations are using what we call room block management techniques, and use various techniques to encourage or require their attendees to book within the official room block. So that way, when the attendee is deciding to go to this meeting, they don't have the ability to go to Travelocity. They don't have the ability to go to other wholesale sites to book their room outside the block, because as part of their booking process, they have to book in the official room block. And if you do that, it eliminates the issues involved in rate protection, because they can't take advantage of any lower rates. It eliminates the need for room block audits, because there's no possibility that people are booking rooms outside the official block trying to get a lower rate. It also reduces attrition issues, because people are kind of, for want of a better word, forced into the official room block. You can either do it saying you have to book in the official block, or you can say you get an incentive to book in the official block. So if you book in the block, your registration is $50 less or something like that than if you don't book in the official block. That kind of incentive gives your attendees the option to say, I don't want to stay at the official hotel, I want to stay at Aunt Mary's house and save a couple bucks. Well, if they have to pay a higher registration, maybe it won't be worth it to stay at Aunt Mary's house, and so they'll stay at the official hotel, and that reduces your attrition obligations. So those are real trends that I see in the rate protection issue. Again, less applicable in the incentive market, but you know, something you guys should be aware of when you're working in the industry in general. Susan, let's go to the next slide. Confidentiality clauses. This has become one of the biggest trends I have seen in the industry in the last few years. More and more customers are requesting confidentiality clauses in their contracts, and they're often very long and very involved. And I look at them as really a solution looking for a problem. And by that I mean they build in these clauses that say that the hotel is responsible for protecting the group's confidential information and making the hotel responsible if there's any leak. Now, we have seen all kinds of situations in the media in the past few years where there's been an event held at a hotel and somebody leaks information about what was going on, what was discussed. At an incentive trips, there are leaks about what the customer was paying to bring their people to this resort for what people think is a boondoggle. You know, there's all kinds of leaks about that. The problem is that putting a confidentiality clause in the contract with the hotel isn't protecting you really from those kinds of situations. The hotel doesn't want confidential information in order to host an event. And, you know, I always say with great respect to our customer friends, we don't really care what you're talking about in your meeting. So if you're bringing an incentive trip to a hotel and they're going to have one meeting during the event where they talk about their product line or something as part of their program, hotel doesn't care what you're talking about. They're going to provide the same service regardless of the content of the meeting. You know, next week they're going to have a different group and they're going to provide the same service in the same facilities. Doesn't matter to them. And they don't want your confidential information because they don't want to have to be responsible for it, and they don't want to open themselves up to liability if something should get leaked. So if you're dealing with a customer that says the fact of our meeting is confidential, or you know what we're doing at the meeting is confidential, or something like that, instead of building in these clauses that just say, here, hotel, you're responsible for making it confidential, what you should do is partner with the hotel to figure out what are you trying to protect and how do you protect it. So is it that the customer is going to be talking about confidential information that they don't want leaked? Or is it that they don't want their competitors in the house or other people knowing that they're there or what's going on? And then build a clause to protect those things. So if you're talking about secret information, make sure that the AV company doesn't get to keep a copy of whatever your presentation is. Have shredders in the meeting rooms to shred any information that is handed out during the event so that it can't get leaked. If you're worried about, you don't want anybody to know that you're there or what you're doing while you're there or what you're spending, have extra security so that there's no ability for somebody to see your lavish reception or whatever it is you might be doing and taking a photograph and posting it online. So don't just put all the responsibility on the hotel. Work with the hotel to come up with a plan to protect whatever it is that is sensitive about your event. And that's a better way to deal with those kinds of situations. You know, and I always make the joke, if you hand out the secret information during the event, it doesn't help to have a confidentiality clause that binds the hotel if your attendee takes that secret information and goes into the bar after the meeting and has a couple drinks and leaves the secret information, and then some guy walks in off the street and picks it up and spreads it to the world. You know, we live in an era where things are so easy to disseminate. You've got to have a clause that helps you and the hotel decide how you're going to protect those kinds of things. Susan, next slide. Force majeure. This is the other big trend in the world that we live in, and there's so many things going on that impact events, and I think it's especially important in the incentive market because you're dealing with people who, for the most part, want to go to the event but don't have to. And so they're more likely to be impacted by things that may influence their desire to attend whatever this event may be. The first thing you need to know and understand is that a true force majeure is very, very limited under the law. If you don't have any clause in your contract, you are still protected if there is a force majeure. So if something happens beyond the party's control that makes it impossible to perform, both parties are excused. You walk away as if there was never an agreement and nobody owes anybody anything. So that's the case if you have nothing in your contract. If you put a clause in your contract, then the terms of that clause will control over what the general law would say. So if you put a clause in the contract that says, you know, if it rains on Tuesday, we can cancel, then if it rains on Tuesday, you can cancel, and that's fine. And if the parties agree on that, then that's what a judge or a court is going to enforce. But what you have to recognize when you're negotiating these clauses is to think about the difference between I can't and I don't want to. I can't means the hotel burned down, so you can't have that meeting. I don't want to means I could show up, but something has happened that means I don't really want to be there. Most of the time, if something is an I don't want to, it's not really going to fall under your force majeure clause. And incentive trips, as we're going to talk about, are more likely to involve I don't want to situations. And so you're going to have to start looking at contracting to address those I don't want to problems. Susan, let's go to the next slide. So in today's world, what is and what is not really a force majeure? In general, politics is not a force majeure. So if you've got bathroom laws like North Carolina, excuse me, or Arizona where I'm from, we had the anti-immigrant law a few years ago, or whatever is going on in whatever state, and every day it's a new adventure as to what they're talking about. Generally, politics is not a force majeure unless you build it into your clause. So you can't assume that just because a state does something that your attendees don't like, that you can walk away from your contract. The current travel ban, and I'm using this in a large sense, the latest version of President Trump's travel ban is currently not being enforced. It's a subject of various litigation. So since it's not being enforced, you can't rely on it to cancel an event. And I am hearing in various industries and various events that there are foreign travelers that are electing not to come to the United States because they're concerned that the travel ban may suddenly go into effect, or they're just concerned that in light of the political climate that they will face additional screening or harassment or whatever it might be. If you're planning a meeting where you know you're going to have lots of foreign travelers and you know that that's an integral part of your event, you're going to need to build in something about that into your contract, because the mere fact that foreign travelers say, I don't want to come to the United States because I don't like them for whatever reason, that's not a force majeure. Fear of terrorism. You know, unfortunately, terrorist acts happen almost every day. We've become almost numb to it. But especially, again, in the incentive market when people aren't necessarily required to go anywhere, if there is a bombing in France and your group is planning on going to France, your attendees may say, I don't want to go there anymore. But that's not a force majeure. Fear of anything is not generally a force majeure. There are limited cases that say that if there's an objectively reasonable threat, that it may allow parties to get out of a contract, but let me assure you it's very, very narrow. I see these clauses that say terrorism or threat of terrorism. A judge is not going to be able to enforce a threat of terrorism as a force majeure, because since 9/11, there's been a threat of terrorism every single day, you know, ever since that occurred. So threat of terrorism is not going to get you out of a contract. Next slide, Susan. Zika. There's been a lot of publicity about Zika. I had a ton of cancellations last year, like in Puerto Rico regarding Zika. Generally, a threat of disease is not a force majeure because there's a threat of disease everywhere. This year it's Zika. In the past it was swine flu or H1N1. In Arizona, where I live, we have something called valley fever that most people have never even heard of that can be fatal. You know, there's Lyme disease. The list goes on and on. So in general, fear of a disease is not going to be a force majeure. And the bottom line is, yes, that is out there, but it does not make the performance of the event illegal or impossible, so it's not going to excuse you. Storms can be very subjective. You know, it depends on where the event is being held. In Atlanta, if it snows a few inches of snow, then it kind of shuts down the city. If it's Chicago, you know, it's business as usual. When you are contracting for your events, you need to think about where it is and what the potential for storms are and how that might impact your event, and build that into your clauses. We've noticed in the past several years, and it's probably a smart thing and a good thing, that airlines are being much more proactive about canceling flights when they're faced with storms coming. But you need to consider that if your event is in a place where suddenly your people may not be able to get there, you may want to address that in your clauses. Susan? So when you're negotiating the clauses, the first thing you need to think about is, when you are asking a hotel to agree to a clause that lets you get out without payment for anything beyond strictly illegal or impossible, you are asking the hotel to say, we can walk away without payment for something that the law would not require. So you're asking for another concession. You're asking the hotel to take on more risk that this event that they're booking a year or 2 or 3 out may not happen, and they may not get paid for it. And that's really the essence of the force majeure clause, is you're not paying for walking away. You always have the right to say, you know what, we're not going to do this event, and here's your cancellation damages. You can always do that. What you're doing when you're expanding the force majeure clause is saying, we're not going to have this event, and we're not going to pay you. So in the case of North Carolina, you're saying, we're not coming to North Carolina hotel, and we don't want to pay you, even though it's the legislature that you had nothing to do with that passed this law. So that's, you know, you need to come at it from that perspective and then work with the hotel to say, here's our concern, here's what we're worried about, especially in the incentive market. Our people aren't required to be there, and so we need to address what these issues may be. make your clause as objective as possible. So instead of just saying bad weather, or instead of saying, you know, fear of disease or threat of disease, say if there's a CDC level 3 travel warning, everybody knows what that means. It's defined by the CDC. The CDC is saying, don't go to this place unless you have to. That would be a reasonable basis for getting out of a contract. Or you might want to say a National Hurricane Center hurricane warning. Again, that's better than just saying in case of a hurricane. You know, that's too vague and too open-ended. And then consider sharing the risk. And this is something I really recommend that parties think about doing more than they do in general. Instead of saying, if this thing occurs, we get to walk away without payment, say, if this thing occurs, we'll pay you half of the regular liquidated damages, or we'll pay you, depending on how far out it is, we'll pay you a quarter, or whatever it is. Share the risk rather than putting all of the loss on the hotel. You're going to get a lot more assistance from the hotel when you do that than if you simply say, we want to walk away because of fear of Zika. Share those damages so the hotel has something rather than nothing, and you're going to have a much better chance of negotiating the clause. And again, you should be very forthright with the hotel and say, here's what our event is, here's who our attendees are, here's what they're sensitive about, whatever it might be, politics or Zika or, you know, name it, and then build in something where you're sharing that risk rather than putting all of the risk on the hotel. And then another option is to say, if something like this comes up, we agree that we'll move this event to another hotel in the chain. Now, I know you all are sophisticated, so you understand that each hotel has a different owner, and moving an event from one, you know, Marriott to another Marriott or one Hilton to another Hilton doesn't really make the first property whole, but it's something that at least gives the chain the ability to try and work internally to try and smooth out that loss, rather than just letting you walk away because something comes up that makes your people not want to come. Susan, I think that's our last official slide. Is that right?
Yes.
Yeah. And so now we're going to go to our questions.
Yes. I would like to point out that on the force majeure issue, we used to never have force majeure, and in the last several years, we've had a Zika, we've had 2 terrorists, and because we always stayed either with that hotel at a later date or with the sister hotel on the property, we've never had to suffer damages with clients. And agreeing to go back to that hotel at a later date, that was probably part of what was in your thing about moving the event to another hotel chain. But that's been really successful with us, because eventually the terrorism date passes. So now to our, go ahead.
And just to add to that, I mean, again, it's a much different conversation. If you come to a hotel and say there's been a terrorist attack and we don't want to come here and we don't want to pay you, that's a very different conversation than saying there's been a terrorist attack and we know that it's not really force majeure, but can you help us by helping us move or come back at a different date? You're going to get a lot more cooperation than if you say, you know, we need your help, rather than saying we're just walking away and we won't pay you. So that,
gotcha.
You know, that sounds like that's what you did.
Yep. Okay. Okay, my first question is, what are the newest challenges from the perspective of the hotel in regards to group contracting? Have we covered? I mean,
we've covered a lot of them. You know, the challenges are always that customers are asking for clauses that put more risk on the hotel, and you've got to understand that, you know, hotels are in the business to make money. They've got ownership and shareholders that they have to report to, and they have to have definite business on their books that they can say this, you know, this $500,000 incentive trip is going to be here next year. And so when you're asking for these rate protection clauses, that means that they don't know what the rate's going to be, and you're asking for these loose force majeure clauses, then you're making your event less attractive to them because it's not firm business. So you want to come in with firm business that hotel can rely on. That would be my response.
Okay. When contracting a meeting more than 3 years in advance of operation dates, are there any particular strategies that you recommend to minimize the client's exposure in event of a cancellation, or anything else to do with being that far out in a contract?
You know, when you're booking an event far in advance, I think it's a good idea to build in review dates where the parties agree to sit down and review the circumstances. You know, if you're having events in the intervening years, maybe to go over your history and reach mutual agreement on adjustments that may be necessary. Or you might want to build in review dates that allow you to release a certain portion of your block without liability. From the hotel perspective, they would rather know 2 years out that your event is not going to materialize at the same level than 2 months out, especially in the incentive world when you're usually going to resorts that have really long booking windows. If you tell them a year out, you know what, we need to drop back by 20%, you're going to get a lot more cooperation than if you tell them 6 months out, because 6 months out, they've got very little opportunity to refill that. So either build in review dates where you get a certain amount that you can definitely release without liability, or review dates that the parties sit down and negotiate to do that. But don't wait until the last minute. That would be my advice.
That's excellent advice. Past industry education events have advised to have dual indemnification. Now we're hearing that to have it only one way. Which way should it go? Most contracts I see are group agrees to indemnify.
Yeah, here's the concept on indemnification that most people don't understand what indemnification really means or how it really works. Indemnification means I get sued because of something that you do, and I want you to pay me back because I got sued. And so what usually happens in the hotel industry is that the hotel, this dates back to the common law of England, hundreds of years ago, innkeepers are responsible for what happens at the inn. And so in the hotel industry, hotels can get sued and be held responsible for injuries that the group causes, even though the hotel didn't do it because it happened on their premises. And so the hotels would build in indemnification that say, if I hotel gets sued because you group caused some injury, I want you to indemnify me. I want you to pay for my lawyers. I want you to pay for the settlement or the judgment or whatever it might be. A lot of people say, well, if something's good for one side, it's good for the other, and so they build in mutual indemnification clauses, and they are very common throughout this industry. I personally, and this is me, Lisa, I'm not speaking on behalf of any of my clients because I have clients that do a whole bunch of different kinds of things for their own reasons. I'm saying me personally as a lawyer, I don't like mutual indemnification clauses. I don't like them because I think they don't help anybody. Because what happens is Susie goes to the meeting. Susie, during a presentation, a speaker says, everybody stand up on your chair and cheer. And Susie stands on her chair and the leg of the chair breaks and she falls off and breaks her neck. Susie, in today's world, will sue the hotel because their chair was bad, and she'll sue the group because the group encouraged her to stand up on the chair. If you have a mutual indemnification clause, the hotel gets sued and they take their suit and they go to the customer and they say, here, you agreed to indemnify me, pay for the lawsuit, pay for the claims, pay for everything. And the group says, well, gee, that's funny, I got sued too, hotel, you indemnify me. And what ends up happening is it cancels each other out, and the hotel pays its own legal fees and the group pays its own legal fees. And 99+% of all personal injury cases ultimately settle without going to court, so there's no determination of who's at fault, and so everybody ends up paying their own expenses. So I think mutual is not really helpful, which is why, certainly from the hotel's perspective, the hotels would rather have an indemnification clause where the group indemnifies it, because the hotel will likely get sued no matter what happens, and the group is less likely to be sued because of what the hotel does. So that's my indemnification 101.
Okay, now we have a question about registration process. There's a travel waiver on a registration, and they do things like by submitting your registration, you and your guest agree to the terms and conditions below, that this company maintains no control over the personnel, equipment, or operations of any air, water, or surface carrier, limousine, bus. It goes on and on about all those things that they're not responsible for with third parties. Does that actually help you, or does that just make the lawsuit more pages when it comes?
Well, I think maybe both. The law on pre-injury waivers, which is what this is, you're saying, look, before you even come to this event and get hurt, I'm telling you, you can't sue me. And the law on pre-injury waivers varies from state to state, and even country to country, so it depends on where your event is taking place and where this injury occurs. It varies substantially. Some places they're enforceable, some places they're not. On the other hand, if you put this in here and Joe attendee gets hurt and they make a claim, this is your first line of defense, and you say, look, Joe, you signed this waiver. You don't have a claim against us. And sometimes that's enough to make the whole thing go away. In other states, they may fight it, but I don't think it hurts you to do this, and it may help you. It may disincentivize somebody from making a claim against you. So give it a try. You know, if it turns out it's not legally enforceable, well, then you should have insurance to cover you. But it's certainly worth a shot to see if it minimizes those claims. So I would do it if I were a tour operator.
Okay, this is right off of the internet from one of our listeners. It goes back to your force majeure. You talked about the Zika virus not specifically being. If you want Zika in there, what should you do? Should it be a separate codicil about Zika? Should it be specifically mentioned? If there's Zika within so many miles of your property, how much detail should you put in there if the client insists on a Zika clause?
I think that that's a really good question and interesting way to approach it. I would not just stick the word Zika into my force majeure clause. I would have a separate clause that says what happens in the event that there's Zika, and it would take some wordsmithing, and I would recommend that you get an attorney to help you. There's a number of attorneys in this industry that represent the customer side. Get somebody to help you, because just saying if there's Zika in the area isn't enough. For example, you know, they had 3 or 4 cases in the Miami area last year. Well, Miami is a huge place, and I had hotels that were 10 or 15 miles away from where the Zika was reported. So would they fall under your clause, or would they not? You know, I think you would need to build in things like how close the Zika would have to be, some indication of how many cases there would be. I would tie it to CDC warning levels, so you have objective things like that. But if you've got a customer that is very worried about Zika, if you've got a customer that has a lot of childbearing age people that are going to be in attendance, it might be something that you want to address. And again, even if Zika would not be considered a force majeure under the law, if you have an objective clause that has clear criteria as to under what circumstances you can walk away, then you'd be able to enforce that. So it's something to think about.
Well, now you won't be surprised, Lisa. I have a whole bunch of questions that have to do with money. And I'm gonna hit you with those, kind of try to tie them in a little bit. One is to resolve rate protection. In our industry, in an incentive program, you like to book the air 6 to 8 weeks out. Now that doesn't always happen because of late registrations and people changing winters and that kind of stuff. But ideally, you like to book at least 6 weeks out. So to resolve rate protection, what about a rate protection up to X number of days before the group dates? So by the time you're reasonably sure everybody's going to be booked, then they'd have to already have their extra rooms by then, or they wouldn't change the dates on their flights. Do you think that would be more acceptable to the hotels? If they still have like a 30-day window to lower rates?
I think that's a great idea, frankly. And I haven't seen that, but yes, in your market, you're saying, look, 6 weeks out, we'll be in place. We know what we're doing, and after that, you can sell your rooms at whatever rate you want. But up until that 6 week out period, you agree you're not going to offer a lower rate, and if you do, you'll turn it off. I think that a hotel would be much more willing to accept that, because usually those lower rates that they're offering are, you know, right at the last minute when they've got inventory left to sell. So yeah, I think that's a good approach to it.
Kudos to whoever wrote us that question. Thank you very much. Okay, should planners be requesting commissions on unoccupied paid rooms, attrition rooms, or when 100% cancellation applies? Shouldn't we also get our commissions back from that if the hotel's getting paid in full?
Well, there's 4 or 5 different things brought up in that clause, in that question. Generally, commission is paid for filling a room, providing revenue to a hotel. Commission is usually meaning a head in the bed. And so if a room is not occupied but is paid for, there's not a head in the bed. And in the resort industry, the hotel often makes more on ancillary revenue, you know, the bar, the beach rentals, you name it. They often make more on that than they do on the room rate itself. And so often they are not willing to commission because they're not getting the value of that room, even if it's paid for. So that's a negotiation process. You can ask, you may not get it. That's the reason the hotel will usually say no. When there's 100% damages, that's a red flag. And I know hotels do it all the time, but if a hotel is charging you 100% of the value of the event and they're not providing you services, they're actually better off by getting that than actually providing the services, and the law won't enforce that. So what I mean is if you've got a $100,000 event and it cancels and you have to pay $100,000 for the hotel is not incurring the cost of providing you those rooms or the food or whatever it is, and so the hotel is better off by getting that $100,000 for the cancellation. So when you're negotiating those cancellation clauses, if you're seeing 100% of the total value of the event in the clause, it's something you should be pushing back on because it's probably unreasonable and too high. Again, if you're in a resort setting, you have to look at, is that 100% just the room value and not covering the food or not covering all the ancillary, but it should be the subject of negotiation. You shouldn't just fall for that 100% right off the bat.
So have you seen trends in the hotel side where the hotel contract is putting more and more lost profits in besides just room? Are you seeing that?
I'm not sure I understand your question, Tim.
Well, when they're asking for full cancellation penalties, lost profit on F&B and that kind of stuff, are you seeing more of those kind of?
Well, I mean, hotels, regardless of the market, hotels are going to expect to be paid for losses on their guest rooms and losses on the minimum food and beverage commitment. Sometimes they're going to ask for more than that if it's in a resort setting and there was going to be significant ancillary revenue. The point is, it shouldn't be 100% of all revenues. It should be some lesser amount that's a reflection of what the profit would have been. No hotel knows what the profit is on any particular room, but they know their overall margins and, you know, depending on season and all that kind of stuff. And so, you know, if a hotel is asking you for 100% of all revenues, that's probably too much. If they're asking you for 60 or 70 or 80% of their revenues as cancellation damages, that could be okay depending on the nature of the event.
You know, you mentioned,
it doesn't have to say profit. It doesn't have to have the word profit in it anywhere. It just needs to be a fair amount.
Okay. You mentioned the buyers and the sellers market. One of the things that we're faced with now in our industry is we actually had a client last fall ask us to start the incentive program, and we weren't going to book a room until this December. We were going to just tell people they're going to go on a great trip, because they were so used to getting incredibly low rates 3 and 4 months out. They think that's going to still happen. Now, we did our best to explain to that client that they were being idiotic, And that's probably why we didn't get the business. But we did our very best to explain to them that there's nothing worse than promising people an award and then not being able to deliver the award. So we advised against taking that route. What are you seeing in regards to trends along attrition blocks? And I loved your review process. We're going to, if we take away $1 million idea from this, that review process alone is a great one. But what are you seeing as trends along the attrition dates? Because now we see the hotel swinging the other way. They're getting far less willing to work with you. There's lots of pushback. You know, 3 rooms used to never be an issue when you hit an attrition date. Now, 3 years, people dig their heels in. What are you seeing on your side?
Well, again, it's a negotiation, it's a process, it's a partnership. You know, everybody should remember where they were 2, 3, 5 years ago, and you know, all those things can change. And that's why I like review dates, because parties should be able to sit down and say, let's be realistic. I mean, from your example of the customer that wants to tell its people that they're going to get a great trip, but then the customer's not going to book it until 3 months out, I think they're going to find themselves disappointed because, you know, those 2 years ago maybe, or well, more than that, 5 years ago, they probably could have gotten away with that. But booking windows are not that short anymore, and they're going to have a difficult time finding something that they're going to like 3 or 4 months out. So I think it's okay to, I think you should suggest to your customers that they've got to book far enough out that they're getting the deal that they want, and then they've got to build in review dates and work from there. And again, your leverage depends upon the volume of your business. So if you can go to a hotel and say, I have the ability to bring $10 million worth of business from my clientele to your hotel within the next 5 years, you're going to get a different negotiation than if you say, this is the only time I'm ever going to bring a customer to your facilities. And, you know, I know that you can't necessarily guarantee that $10 million, but if you can show them the history of what your company is able to place, you're going to have more bargaining power. Is that helping?
Yeah, it sure does. It sure does. Another question, since the standard contract blocks double rooms, does that give the hotel the right to charge you for double rooms if you end up having some singles? How would you handle that when it comes to attrition?
Well, you know, a lot of times the hotel will say your rate for singles and doubles is the same, or what you can do is you can negotiate a rate for run of house or standard rooms or whatever you want to call it, and then have an additional person charge. So in other words, rather than booking 100 singles and 100 doubles, say we're booking 200 rooms and we'll pay an additional $25 a night for every additional person we add to the room. And then you're setting a minimum with a potential extra rather than the extra that you're trying to get rid of. Does that make sense?
Sure. Sure. I'm going to ask you about a problem we have with on-site illnesses. You know, everybody's heard about the cruise ships that have, I can't think of what the name of that is.
Norovirus.
Yeah.
Mm-hmm.
But, you know, I've been to some 5-star hotels in your neck of the woods up in Scottsdale where 47 of us came down with food poisoning, and it was the kind, you know, with hallucination and missing the home meeting and just really, really bad. From your comment along fair and reasonable, given something as severe as somebody missing 3/4 of the events because of a problem clearly caused by poor food handling at the resort, that's not necessarily going to be in the contract up front, where would you advise a client like us to come from on that, on the backside? I mean, obviously we're going to ask for any kind of medical charges to be borne by the hotel. But what about asking for those people who missed 3/4 of the event to have a certificate to come back for so many days on the hotel? Can you give us an idea on the fair and rational side where you might come from an event like that?
Well, a couple of things here. The first thing I wrote down when you said this, you said it was clearly caused by poor food handling on the part of the hotel. Well, if you're coming to the hotel with that standpoint, you're probably going to be met with resistance, because if you've got a 500-person event and you got 50 people who are sick and they all went to the same banquet, it's not clearly caused by poor food handling. You know, there's a million ways that people can get sick and a million things that could happen, and you can't leap to the conclusion that it's poor food handling. And people tend, and I'm included in this, I used to think that food poisoning was something that if you eat dinner tonight, you're going to be sick tomorrow, and, you know, you can trace it back to dinner. It can take a lot longer than that, it turns out. So the first thing you need to do when you're having these events is you need to tell your attendees, if you have an issue, you need to let us know right away so that we can respond. And then you need to notify the hotel. Don't ask the hotel to notify you if anybody tells them that they're sick, because for privacy reasons, a hotel is not going to release that information unless the guest tells them that it's okay to do so. So you need to manage your attendees and say, we need to know if you've got an issue, or you need to give the hotel permission to let us know. And then the sooner that you bring it to the hotel's attention, then they can call in the health department, they can do an investigation, try to narrow down what's going on. But if it's a situation where 50 people are sick out of 500, don't assume that this is the hotel's fault. It could have been that those 50 people went off site for lunch and got sick somewhere else. It could be they got a virus on the plane with the people they came with. So ask the hotel if they're willing to give you some accommodation. Don't go around blaming it on the hotel. Say, gee, you know, everybody's sorry you got sick. Here's something that we'd like to do for you, rather than saying the hotel's at fault, because that's not necessarily the case. I had one of these here in Arizona. There were 2 events in-house at the same time. Some people, and they had the same menu for their lunches. Some people at one of the events got sick and immediately blamed it on the hotel and demanded a free meeting and all this kind of stuff. And the health department was called in, and it turned out it wasn't the hotel's fault. So you got to be cautious in those situations. The main thing from you as the event organizer is to make sure that your people are letting you know the minute that those things happen, so you can jump in, do the right investigation, and work with the hotel in partnership to try to make it right for those people.
Okay, well, we have one more question about this line. And one of our planners had the unfortunate luck to have over 70% of their attendees get so sick that they couldn't go to any of the meetings, and they ended up canceling the meetings that they'd all paid to attend. What, in a situation like that where it's 70%, I would doubt that, and this was a big number group, I doubt if there's any way to say they got sick on transportation or off-site issues during the meeting of the deal. What would you suggest on something like that? Because these are the things that aren't up in a contract beforehand. You don't want them to be, because you can't imagine that many people getting sick at an event, but it does happen. Yeah, well, that's terrible. I mean, if everybody's been on site together and they're all eating the same meals, and suddenly 70% of your people are sick, again, health department needs to be called in right away. Hopefully you'll have some event insurance that may apply to cover that. And I think you should make ask the hotel what compensation they're going to provide. The hotel would probably then call in its insurance carrier, and yeah, it sounds like some compensation would be appropriate in that kind of circumstance. And again, it depends on the value of the event and, all those kinds of things. So I can't just pull a number out of the air, but I would expect in that circumstance that the hotel is going to give you some compensation. But let me emphasize again that it's a good idea for the customer to also have event cancellation insurance, especially in the incentive market, because there are so many reasons that you might decide that you can't have this event, that it's good to have that coverage to fill in for those costs that you were going to incur. Okay. And our last question, and thank you so much, Lisa. I really appreciate your taking the time and sharing your professionalism with us. So we're going to add review dates now. So if we put review dates in the contract, would you add stipulations that are very specific, such as if X changes between now and then, or would you just leave it that we're going to review and we can have X percentage change based on current status? How specific would you get?
Well, the answer is always the more specific, the better in any contract situation. So that's the general rule. I can't speak to what you should do because it's going to depend on your event, your customer, where you're going, you know, a million different circumstances. You know, from the customer side, it's in your best interest to say, by January 1, we can reduce by 10% with no liability, because then you know what you've got. Your hotel may not want to do that, so you may say, you know, we're going to review in February, and if we mutually agree, you can reduce or whatever. So you know, I can't give you specifics because it depends on too many different factors. I know you want more, but I'm not going to negotiate your contracts without the right information.
I understand. Well, Lisa, thank you very much. And people that have been listening in, Lisa's contact information is on our website, and feel free if you need some expert counsel. She is a person that works in our industry on both sides of the field, not just for hotel.
I only work on the hotel side. I don't work on the group side.
Oh, all
right.
I'm sorry.
If you need help, I can certainly give you guys the name of people that work on the group side, and I'm happy to share that with you.
Okay. Well, thanks for clarifying that for us. And sure. And I want to take, again, for Site Midwest, thank you for making this a great seminar. And everyone, we will sign off now. We'll see you June 6th and June 7th in Kansas City and St. Louis, Missouri. Thanks all.
Bye-bye.
Bye-bye.